Yes. Memos you want to give your memo.
I've given a memo, my lords. These are two repetitions of the year 20
Do you need to explain?
for withdrawal, my lords. For withdrawal.
Withdrawal
Matter has been settled. Checks I'll hand over. Monday tha 6 तारीख.
Specific.
Great.
Supplemental list, page 1.
My lord, I beg your lordship's pardon, my lord.
Yes.
My lord, item number 20.
So you have to go page wise. I beg your pardon to go page wise.
Item 4 to 8.
Item 2, lordship. My lord, on behalf of Bijali, my lord, can you take
Two, you have to wait.
My-
You have to wait. For 2, you have to wait.
My
4 to 8.
Item 6, my lord.
My lord's item 7.
6.
My lord's item 7.
Just one second. One after Mr. Sir.
Right.
I will pass the order when the matter reaches. 7, sir.
My lord's item 7.
Mm-hmm.
Actually, last hearing on 19th May, that was a special arrangement hearing. That's why, my lords, the order copy is not uploaded in the internet, in our High Court website, lordship.
5 order ta hai nahi.
No, upload hai nahi.
Achha.
So, lordship, I request I'll file the affidavit in the next. In the next. I'm sorry.
95 to jo upload hai nahi apon janibe kemti.
1980 देखिली लॉर्डशिप एबे जस्ट देखिली कंप्यूटर देखो जी किंतु ऑनलाइन अपलोड हेनी
कोन
सेटा गोटे स्पेशल अरेंजमेंट रे थिला हियरिंग टा से दिन पीसी रे थिला
the system special is impacted hava katha no.
आगे
Kana because that is how I have realized that unless they handle the physical copy, they cannot handle it.
लॉर्डशिप केस नो
ठीक है, that order has to be passed. You are Mr. Badi?
पी जाती
P. Jatti.
लॉर्डशिप
That order has to be passed when it reaches, because without an order that cannot be done. Yes, next page.
Page 2, 9 to 17.
And the date has to be fixed.
लॉर्डशिप
My lord, item 12 on behalf of Dipti Rakhana, kindly urgent to next week.
The matter was heard at length on 15/4/2026. Item 12, Mr. Sushant Kumar Sahoo on behalf of Dipti Rekha Nanda for the petitioner. Opposite party blank. The facts and as well as the propositions of law were noted. The petitioner had adjournment. Tomorrow, Mr. Sahoo. Petitioner had adjournment to address on the propositions as noted in the said order. Thereafter, on 6/5/2026, the matter was again adjourned at the none appeared for the petitioner, and the matter was adjourned. Today, after more than 2 months, again adjournment is sought for on behalf of the petitioner. Apparently, the effort of the petitioner is to file the case and adjourn the same repeatedly. Stop. Today, the matter being in the list is mentioned on behalf of the learned counsel for the petitioner seeking adjournment. Adjournment is granted reluctantly. The matter shall be listed in the week commencing. Go to
Odisha.
20/7/2026. Copy of this order shall be forwarded to the learned court. Learned execution file ichi. That the learned judge forwarded to the learned judge family court to be kept in the records of criminal proceeding number 212 of 2023. Disposed of by judgment dated 24/10/2025 by the registry. If the learned judge family court Bhadrak shall also send a report, if any, execution case has been filed arising out of the state criminal proceeding and status of the state execution case. Yes. Next.
My lord,
The matter was taken up on 11/3/2026. Adjournment was sought for by the petitioner. Thereafter, on 31/3/2026, the matter was heard at length. The propositions of law as well as the facts were noted. The learned counsel for the petitioner had adjournment to address on the propositions as noted. The paragraph 12 of the said order dated dash in the following was directed. Learned counsel for the petitioner up to 500 only for them. Thereafter, again the matter was adjourned on 34/2026. Stop. Apparently, for the last more than 3 months, the petitioner's effort has been to adjourn the matter after filing the revision application. Para. Today, the matter being in the list is mentioned at the beginning of the day's proceeding, seeking adjournment. Stop. Adjournment is granted reluctantly. The matter shall be listed in the week commencing 27/7/2026. Registry forward copy of this order to the learned court, learned judge, family court, Kendrapada, to be kept in the records of criminal proceeding number 269 of 2013. The learned judge, family court shall also furnish a report regarding pendency of any execution case arising out of the state's criminal proceeding number 269 of 2013. And if any execution is pending, execution is filed, the status of the same shall also be intimated. This is a problem because there is a Supreme Court direction to dispose of execution cases, Supreme Court directions to dispose of maintenance matters. But this court is participating in your efforts to frustrate that. Please go through those decisions. Apart from seeking adjournment at the instance of the CEO learned senior, please go through those decisions. Which decisions? Regarding execution. Which one? Sorry? Go through that. Make an effort. Why the Supreme Court has expressed concern and issued guidelines in Article 140 and 142. Yes, next.
My lord, item number 8.
8. 8 not like Jack out of the box. We are at page 2, 9 to 17. You have to be more patient than you are.
Item number 14. The Lordship has been pleased to direct me to file an affidavit because of some family disputes.
So, Nalini Kantana Sahoo for the petitioner.
Yes. So this affidavit could not be prepared and some instructions is required.
For that, at least the court is not responsible.
No. My lord,
So, don't take credit of which for a mistake on your part.
yeah, that is my submission.
That can't be a submission that you have committed certain mistakes, so you should be. That's
No,
not the
I beg
concern
your
of the court
lordship's-
also.
I beg your lordship's indulgence for that, my lord. That some time is required.
Why should I show indulgence to any particular lawyer?
Some time is required for my lord's
Time
compliance.
is granted, Mr. Sam. After grant of time, I cannot show indulgence because I like you.
No.
Or I like Mr. Das.
No.
So please don't do that. Even if you feel that I like you, don't expose it like that.
No, not that, my lord. I need some more time. That is my humble submission.
Sir, whatever you asked, that was granted. You require time for the eternity.
No.
What? No. You are saying that only. Whatever you asked, that was granted. And that is the advantage of for the court being lenient in granting time, so that you don't complain. The matter being in the list, the matter having been listed for fresh admission, item 14. It mentioned at the beginning of the day's proceeding by Mr. Sahoo, by the learned counsel for the petitioner. He refers to the earlier order dated 21/5/2026, which was passed after hearing the learned counsel at some length, and the propositions of law as well as the facts were noted in detail. At paragraph 6 of the said order, the following was observed. The learned counsel for the petitioner seeks further time, though the time as sought for was granted. Stop. Taking a lenient view, further time is granted to the petitioner to comply with the order dated 21/5/2026, as well as reiterating the order dated 21/5/2026, which requires response of the learned counsel for the petitioner. The matter shall be listed for fresh admission in the week commencing 27/7/2026.
No, in the earlier order, the lordship has been pleased to mention that in paragraph 19 and 20 of the.
ଏଇଥିପାଇଁ ମୁଁ actually ଡାକେନି, ଆପଣ ଗୋଟେ ଆଉଟ ଅଫ ଟର୍ନ ହିୟରିଂ ଚଲେଇଲେ,
ସେଟା
ଆପଣ ଆଡଜର୍ନମେଣ୍ଟ ଚାହିଁବେ, ତାପରେ ସେଟା ଆଟଲିଷ୍ଟ ରିଚ୍ କରୁ, show some courtesy to your colleague also.
will be on 27 now.
ନାଇଁ କଣ ସେଟା ଟାଇପୋଗ୍ରାଫିକାଲ ଏରର ନା କଣ
ହଁ, typographical ସେଟା
କଣ ହେଇଛି କହୁନାହାନ୍ତି?
ସେଟା ପାରା 19 and 20 କହିଛନ୍ତି, ସେଟା ପାରା 18 and 19 ହବ. That is my humble
19 and 20 କୋଉଠି ଲେଖା ହେଇଛି?
ଆପଣ paragraph 3 ରେ ଯୋଉ ଲେଖିଛନ୍ତି ସୁପ୍ରିମ କୋର୍ଟ ଜଜମେଣ୍ଟ ଟା, paragraph 19 and 20 ଲେଖିଛନ୍ତି, reproduced below, para 18 and 19. I am holding the judgment, my lord's mechanics.
I do have that day. You did not have the judgment. Did you cite this judgment?
No.
So it is a mistaken part of it.
That is
So that is not done now.
that
So as if you hold the judgment and I have cited it
No,
wrongly. No. Nobody is citing that.
no, not that. But
Because if it, then at least we would be elevated. Nobody is assisting that way. ଯିଏ ଯାହା ପାରିଲା କହିଲେ ସେଟା ଆଉ ଥରେ ଆପଣଙ୍କୁ ଯେତେବେଳେ ଡିକ୍ଟେସନ ଦିଆହବ ସେତେବେଳେ ସେଟା ଦେଖିଦେବ. Be submitted by the learned counsel for the petitioner that ଆପଣ କହୁଛନ୍ତି ସେଟା 20 and 21 ହବ?
19 and 20 ଲେଖା ହେଇଛି, ସେଟା 18 and 19.
18 and 19. ଠିକ ଅଛି. ଠିକ ଅଛି. Leave it. Next, 15 to 17, 15 to 30, 19 to 18 to 30.
My lord, item number 16.
ଆପଣ ବସନ୍ତୁ Mr. Jena.
Again,
You have to be more patient in practice.
my lord.
Your impatience as a law officer continues to be in practice. Please sit down. You are just blocking for others. Kindly have your seat.
My lord, item number 16. Pray for
What?
short. Pray for
16.
16.
16.
Pray for short.
Sir, already long you have taken. Why short?
My lord, due to severe
Severe?
viral infections of my senior advocate, he is not.
Due to severe, you have lost your voice also. You are not associated with our senior Mr. Misra.
No.
He demonstrated long back, then when it is impossible to get adjournment, he demonstrated how to get adjournment. Just go to the court and just I lost my voice. Nobody could believe that. I mean, his juniors have become great lawyers. I heard from them. They are my seniors. They were really thinking that today there is no chance of getting adjournment. Your name, sir?
SK Nizam.
Mr. Sheikh Nizam, NEZA, on behalf of the petitioner, for the petitioner, opposite
Yes.
party blank. The matter being in the list, with the matter having been listed for fresh admission, is mentioned by the learned counsel for the petitioner seeking adjournment. Earlier by order dated 21/5/2026, the deliberations after hearing the learned counsel for the petitioner at length have been noted. The petitioner had adjournment to file affidavit as directed at paragraph 6, and the learned counsel was to address on the propositions as noted in the said order. As prayed for, the matter shall be listed in the week commencing 27/7/2026. The petitioner shall comply with the order dated so and so, see order type. The learned counsel for the petitioner shall also address on the propositions as noted. Yes, next. Yes. So, but you file, you have power here to sign that memo, withdrawal memo. Sign kiye kale? Sir करचंती तो? Don't file a withdrawal memo where you do not have power, because that creates problem. रखो किसी का सर. At 19 लिखिचंती तो? ठीक है. पढ़ला वाला order ହେଇଯିବ.
Item 20, my lord.
20, sir. Yes.
My lord, due to my mistake, I could not communicate the petitioner to file the affidavit as directed by your lordship. So I have already communicated. So she is coming on 7th to swear the affidavit. So your lordship, I have already intimated the learned senior counsel, Mr. Acharya.
20 that date कर दे रहे आप.
My lord, any date between 13 to 16 or after 10th August. My senior will not be available.
We commencing 10th August कर दियो. Mr. Acharya.
Well, yes, ma'am.
You accommodate Mr. Acharya. He is saying he's.
Yes.
Simply it is urgent without
Yes, ma'am.
recording any order. By concept.
Interim order to continue.
Yes.
Yes.
Aye.
Mr. Gautam Kumar Acharya along with Miss.
Arpita Ma.
You don't have power here.
I have power, your lordship. A Mahapatra, Arpita Ma.
Achha, yes. Miss A. Mahapatra for the petitioner, Mr. Arun Kumar Acharya for the opposite party. The learned counsel for the learned instructing counsel as well as the learned counsel for the opposite party. Agree for the matter being urgent. Accordingly, the matter shall be listed in the week commencing.
27.
नहीं मना କରୁଛନ୍ତି ना
10th August.
मना कले 10/8 week commencing 10 से ରହିବେନି 10/8/2026
Aye.
interim order dated so and so shall continue till the next date of hearing.
Obliged.
And date you do remember the date. Upon verify करी देखिबे interim order dated so and so shall continue till the next date of hearing.
Obliged.
Yes, next 18.
On behalf of Shalkumar Bora, I think formally request
So what's your name, sir? Durga Madhava Sahoo. You don't have power. Mr. Durga Madhava Sahoo on behalf of SK Barala. Baral for the petitioner. The matter being listed for fresh admission. The effort of the petitioner to get adjournment repeatedly continues. At the beginning of the day's proceeding, matter is mentioned to be adjourned, as it was earlier on 18/2/2026, after hearing the learned counsel for the petitioner at some length. Thereafter on 6/3/2026, 6/4/2026, 1/5/2026. Apparently, the strategy is to adjourn the matter for the last more than 4 months. Stop. To grant further opportunity, adjournment is granted reluctantly. The matter shall be listed for fresh admission in the week commencing 27/7 और 3/8 27. Yes, next.
21 to 30,
31 to 36. 31. ଆପଣ 1 week time ଚାହୁଁଛନ୍ତି ନା କେତେ ଦିନ ଡିଫେକ୍ଟ ରିମୁଭାଲ କରି 1 week after କେମିତି ହବ ସେଣ୍ଟେନ୍ସ ତ ଠିକ ହବ ନା ମୁଁ ଫେରେ ଗୋଟେ ଅର୍ଡର ଡାକିବି ତ ଫେରେ କେତେ ଦିନ ଚାହୁଁଛନ୍ତି ଡିଫେକ୍ଟ ରିମୁଭାଲ ପାଇଁ ହାଉ ମଚ୍ ଟାଇମ ୟୁ ୱିଲ୍ ଟେକ୍ 1 week within 7 working days 31 डेट कभी कभी
वो तो अच्छी 27.
27 week ରେ ଆସିଲେ ନା 27 27 ଠିକ ଅଛି 32
Serial number 36, Your Lordship.
36
Yes, Your Lordship. Yes, you
ଅଦର
can-
ସାଇଡ୍ ଅଛନ୍ତି କଣ
yeah. Okay. I've taken consent.
ସିମ୍ପଲି ଆର୍ଜନ ପୋଷ୍ଟିଂ କରିଦେଲେ ହେବ କମ୍ପ୍ୟୁଟର ରେ
Yeah.
36 ଟା କରିଦିଅନ୍ତୁ
Will come in 10.
10
Much okay.
Pardon, my lord. Item number 38.
10 8 week मिस्टर
35.
35 मिस्टर मिश्रा
But I pray, my lord, can be taken up 2 p.m.
No. Already I have told Mr. Sahoo that I can't show that my personal inclinations. Even if I have, how can it be 2 p.m.?
Not trial.
You stick to Delhi. As you go, so you become outside counsel, to mention that, so it will be fixed at 2 p.m. Yes.
Madam, my lord, that trial court has fixed date to 8 for attachment of some salary.
So we can't be guided by the trial court. We have our hands full. Trial court has its hands full. So definitely, I mean, your point is valid that at times the trial is affected, but the entire effort is to do that. That we, interdict the trial. Let us see. Let us see. Let us see.
Again.
Yes, Mr. Ponda.
My lord, item number 38, your lordship.
Next page.
I,
38. Yes.
Yeah, I'm for the respondent, your lordship.
Mr. Das was here. Yeah, Mr. Das.
Objection in this matter.
No, my lord, my humble submission. Let I may be bless your lordship. Last
अरे मेरिट रे सर केमती हबो बर्तन तो मिस्टर मिश्र जो दीटा वाले भाई पाला आपण एडजमेंट पाई जेती
adjournment mo na
कहले सर एला
suffering from objection question.
से कोन कहले कहले आई डोंट हैव ऑब्जेक्शन सेति पे आपण फेर कर राजी अछंती फेर कोन
My lord, my lord.
Opposite party's husband who is conducting the case at Bhubaneswar court is creating. And so let them undertake not to at least press on fourth, matter is posted to fourth.
I don't know, my lord, because I am out of station. Now I'm suffering from fever and I am unable to speak also, your lordship. Let I maybe take instruction from my.
No issue about
No,
it.
I will take instruction from my friend, my lord.
Yeah.
Immediate plan.
This is out of court.
No, there is a stay or a adjournment order.
No, my, there is no straight.
No stay adjournment. That is what I pray, my lord. Then for the date only fourth.
Yes, Mr. Ponda. Yeah, what is this matter? Negotiable Instrument Act.
No,
No.
it is a suit for rendition of account.
अच्छा
Property as at Raigada.
ତାଙ୍କୁ ବୁଝାନ୍ତୁ ସେ ନିଜେ ଆପଣ କରୁନାହାନ୍ତି ଭୁବନେଶ୍ୱରରେ ତାଙ୍କ ହଜବେଣ୍ଡ କାହିଁ କରୁଛନ୍ତି ଆପଣ ବୁଝୁଥିବେ ଆପଣ no
I will take
Mr.
instruction.
Ponda knows he was doing his father-in-law's case.
Yes, your lordship.
So the difficulty you face when you in-laws
My-
case come କରିବେନି
My lord, because on that day I will not take
because you have to go back to home.
No, se to
He was-
other will be expired
I
kari
remember
gale.
after 10
Last
years
case
from
for
that,
saita.
He said it as my father-in-law's case almost 10 years back. That
Yes,
day,
sir.
that
Se
day-
expire kari gale ni. I will never
ବୁଝାନ୍ତୁ,
know.
ସେଟା କଣ ସର୍ଭିସ ମ୍ୟାଟର ଥିଲା ନା
No. Hello, mines रे se kisi invest करथिले पैसा
ଆଚ୍ଛା
se mines
ତ
में.
ସେମିତି କରନ୍ତୁନି
ମୁଁ ସାଙ୍ଗକୁ
very
ପଚାରିବି.
difficult. You ask any lawyer of worth
Okay,
his salt, he will vouch for this.
My-
That don't do that.
My lord, I will.
You can't simply you can't explain.
ମୁଁ
In
ତାକୁ
any way,
କହିଲି,
in fact, adjournments I have never been able to explain to any class.
No, regarding
Highly
the
educated at the top end
the
of the
conduct
they
of
can't
the-
understand why it is adjourned.
conduct of
Because they
the
don't understand it.
conduct of the hazard, I don't know, my lord. I will take
The
instruction.
conduct of husband no lawyer
Instruct him to
ସେଥିରେ obviously
engage
ତାଙ୍କ
any other advocate.
ସକାଳେ ଯୋଉ ତାଙ୍କ ବ୍ରିଫିଂ ହଉଛି ଜୁନିୟର ବ୍ରିଫ କରିବା ଆଉ କ୍ଲାଏଣ୍ଟ ବ୍ରିଫ କରିବା ଡିଫରେଣ୍ଟ
My lord.
and in house briefing is real challenge.
ମୋର ଦେହ ଅସୁସ୍ଥ ତ ମୁଁ କେବେ ବି adjournment
ଆପଣଙ୍କ
ନିଏନି,
ଅସୁସ୍ଥ
ଆପଣ
ହେଇଛି
ଜାଣିଛନ୍ତି
ବର୍ତ୍ତମାନ।
ହଜୁର।
ସେଟା-
I have never taken an
ଶୁଣୁନାହାନ୍ତି, ସେ
adjournment.
ଅନ୍ୟ କଥା କହୁଛନ୍ତି, ଆପଣ କେମିତି ଅବସ୍ଥା? ତ ଆପଣଙ୍କ ପାଇଁ ତ ଆଡଜର୍ନମେଣ୍ଟ ହେଲା ସାର୍, ହାଇକୋର୍ଟ କଥା ବୁଝି ଗଲ, ହାଇକୋର୍ଟ
ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇକି ତାକୁ ଡାଇରେକ୍ସନ ଦେଇଦେବି।
ଡାଇରେକ୍ସନ ଆଉ ଯିଏ କରନ୍ତୁ
ଆଡଭୋକେଟ ଲୟର
TRPC 317/2025.
ମୁଁ ସବୁ ଫାଇଲ
I'm sorry,
କରିଦେଇଛି।
this is item 38.
30.
TRPC 470. The matter is listed for hearing under the heading for admission. The appearance of Mr. Suryakanta Das for the petitioner, Mr. Nilakantha Panda for the opposite party. The matter being listed for hearing is there is less likelihood of the matter being reached and is mentioned by the learned counsel for the parties at the beginning of the day's proceeding. The matter shall be listed for admission in the week commencing
3/8.
3/8/2026.
On that day, we'll finish the case.
Let us see. 3/8/2026. In the meantime, it is directed that on the next date, that is 4/8/2026, the matter shall be adjourned to a date beyond 3/8 or 10/8 कर दियो तो 10/8 as would be convenient to the learned court in season of the matter. जो matter टा करी case number टा पके. Yes, next. नहीं आगो सार घर मुझे जेना ताको परे से भी मिस करथिले ना से कोते
8 ନମ୍ବରଟା ମୁଁ ମୋ ହେଲ୍ଥ ଗ୍ରାଉଣ୍ଡରେ ଟାଇମ ନେବି ଆଉ ଗୋଟେ ସପ୍ତାହ, କାରଣ ଡ୍ରିଲିଂ କୋଚିଂ ଗୋଟା ବସିବ।
से तो हेड ड्रिलिंग हबो आज्ञा जेतेबेले एरियर पई कोन करिवे
ନାଇଁ ନାଇଁ
बट क्लाइंट रे हेड ड्रिलिंग हो आपण को हेड भलो रहो so that
ନାଇଁ
all of
ଭେକେସନ
us
ଷ୍ଟାର୍ଟ କରିছিল ପ୍ରସାଦ।
Mr. Gopal Prasad Jena for the petitioner, opposite party. That was item 8. The matter was heard at length on 21/4/2026. The propositions of law as well as the facts were noted. At paragraph 6, the following direction was issued. Thereafter, the matter was adjourned on 4/5/2026. Today, the matter being listed for fresh admission is mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding. से पारा 6 पर तो मुंडो घुरे होता पर कौन करिया माने न्यूरोलॉजी कंसल्टेशन ना कौन
ନାଇଁ ଏଇଠି ବି ପ୍ରେସର ଆସୁଛି 103
ଆପଣ ତ you should take care of your health client को मुंडो घुरिया को दियंतु. One of our chief justices used to say I have normal blood pressure but the other side will have the blood pressure. He used to list 600-800 matters per day. He was telling that, and it is a fact that if 800 matters are listed, obviously, वकील का मुंडा तो घुरे वहीं घुरे. Take care of your health, sir. Is mentioned to seeking adjournment to grant further opportunity. The matter shall be listed for fresh admission in the week commencing 27/7/2026. The petitioner shall file affidavit as directed by the order dated 21/4/2026. The learned counsel for the petitioner shall also address on the propositions as noted. Yes, next. 27. Sir, ଆପଣ ପିଟିସନଙ୍କ ପାଇଁ along with the senior Mr. Kanungu. ଏଟା କଣ ଚାହୁଁଛନ୍ତି କହିଲେ?
Petitioner has supplied all the certified copy of the documents of lower court also, and he has supplied the deposition copy of both parties. I have obtained all those certified copies.
No, you want adjournment?
Yes, sir.
27 को आउट दिन को कर दियो. Simply adjourn कर दियो.
Again, those.
और दौनांती ଆପଣ ଫିସ୍ ଦଉଛନ୍ତି ନା ନାଇଁ ଦଉନାହାନ୍ତି ମେଣ୍ଟେନାନ୍ସ ଦଉନାହାନ୍ତି ଆଜ୍ଞା it is not difficult to guess The matter is listed for orders and is mentioned at the beginning of the day's proceeding by the learned counsel for the petitioner seeking adjournment. Since the presentation of the matter on 12/12/2022 for the last more than 4 years, the effort of the petitioner has been to adjourn the matter on one pretext or the other. On 9/4/2026, the matter was heard at length. The propositions of law as well as the facts in brief were noted. Thereafter, on 12/5/2026, the matter was further heard and as noted in the said order. Para. In view of the effort of the petitioner to adjourn the matter in one pretext or the other, adjournment is granted reluctantly. The matter shall be listed in the week commencing 27/7/2026. Registry shall forward copy of this order to the learned Judge so and so, learned Judge Family Court Bhubaneswar, to be kept in the records of criminal proceeding 215 of 2016. The learned Judge Family Court shall furnish a report regarding status of execution case if pending arising out of the said criminal proceeding to the registry of this court, which shall be tagged to the case brief. Did you read the orders of Supreme Court regarding execution? Co-decision.
Which you lordship has 2015.
I am still at Bhubaneswar, sir. I am in Cuttack. Upon Supreme Court pachale, upon your lordship kare. There is a mandate of Supreme Court in 2 cases that execution should not be kept pending, but High Court has kept it pending for 4 years. You must understand what we are doing. That is how we are inviting, so at times very sharp comments or which we are not supposed to receive. What the Supreme Court said, suppose the wife writes a letter to Supreme Court, then 2022 RPFM High Court pending achi and the trial court is unable to proceed with execution. Rahul Saha, upon instruction that is law based hua darkar. Upon jehetu Rahul Saha awarota padhantu. Other that South Indian name, I'm just forgetting. There is a mandate that this matter should not be kept pending. Yes, next. Call karantu patta final.
Item 1.
Sir, Manoj, whatever. MK Panda ka name also did. So MK Panda for the appellant. Yes, madam, what's your name?
Ipsita Pani.
Ipsita Panda. Oh, sorry. Miss Ipsita Panda along with Mr. MK Panda for the appellant.
Pani, your lordship.
I'm so sorry. Ipsita Pani.
Yes, lordship.
Ipsita Pani on behalf along with Mr. MK Panda for the appellant. Mr. Satyasindhu Kashyap, Senior Panel Counsel.
Just now 2.
Mr. Prem Kumar Mahanti for R1, Mr. AC, Mr. Satyasindhu Kashyap, Senior Panel Counsel for R2. Refer Korantu.
My lord, in fact, I have taken specific instruction in this matter because if the matter can be decided in mediation, then that will be better for the case. But here the practical difficulty which I've been instructed to place before my lord is this accusation is
Sir, can I can I start hearing on merits whether to be referred to mediation? Either you agree or you disagree. That's what. How can I pass a order in detail after hearing you for half an hour? Then Mr. Panda, Ms. Pani, and Mr. Mahanti. Merit hearing is different, but then to refer to mediation is an effort.
My concern it can be sent to mediation. If that can settle it between the parties, because the practical difficulty is something different, but let it go to mediation. So that
mediation is overburdened now. And somehow you have to have a policy. I have been requesting both the Lord DHJ as well as the state that please have a policy on this. The Supreme Court has also requested I mean, has intervened. I am made to know that even at the central level also, when they have been discussing, the registry of the Supreme Court has been discussing. Unless you have make an effort for mediation, it can't. Because
as my lord is
Mr.
guide me
Pani,
to
now Mr. Kashyap
yes.
is saying that let it be referred. I refer. There you don't have a choice than to say that we can't go for
Can't.
it.
Yes, true. In that context, already I've suggested, but no outcome is coming till date. Already I've made a suggestion in this regard.
এটা আগুর কেতর লিস্ট হেলানি
তিন তার খন্ডে রানি, 2-3 তার রানি.
Why is it isn't listed for other whether to matter can be
Or other matter, I don't know. Yes.
The matter is listed appearance dekhile. Matter is listed under the heading for referral to the special mediation type 2.0 mediation for the nation. Earlier the matter was listed on 16/3/2026, 10/4/2026 and 14/5/2026. On each of the dates, the learned counsel appearing for the R2 were requested to obtain instruction regarding referral of the matter for mediation under the special mediation drive 2.0 dash mediation for the nation. It is submitted by the learned CGC, learned senior panel counsel appearing along with the learned DSGI. That you have received instruction that there is some difficulty.
is some difficulty with
As per
regard
their
to-
instructions, there would be difficulty in referring the matter to the mediation. Accordingly, the matter shall be listed for this is pleadings are complete,
Lordship. So appeal,
listed for hearing.
LCR may be called for.
After notices were issued, Mr. Panda, Ms. Pani, so they have appeared. The notice issue any.
Notice is
Okay. The matter shall be listed for hearing. A scanned copy of the LCR be called for. Hearing upon date, specific date ଚାହୁଁଛନ୍ତି ନା କଣ? In the week commencing
10/8.
10/8/2026. Yes. Next.
Item 2.
Item 2, my on behalf of my lord, Mr. B. Jelly, my lord. Personal difficulty, my lord. 1 week after my kindly.
Mr. Sahoo.
I have for the respondent number 4.
Last chance, lordship, may give.
Appellant for taking substitution for the legal years of respondent number 3 as well as respondent number 4. I have to hand the order that the 26th being without the
Mr. Pasayat. You are Mr. B.S. Pasayat.
My lord, B.
B. Pasayat. Mr. B. Pasayat on behalf of Bharat Jali for the appellate. Mr. A.K. Nanda along with Mr. G.N. Sahu for the respondent.
respondent number 4.
R4. Mr. P.K. Mahanti, additional standing counsel for देखिए appearance टा ठीक है.
Respondent 1 and 2.
1 and 2. Now 1 and 2. The matter is listed for under the heading for referral to the special mediation drive 2.0 dash mediation for the nation. Adjournment is sought for on behalf of the appellants due to personal difficulty of the learned counsel appearing for them. The learned counsel for the R4 refers to the earlier order. केबेटू डायरेक्शन लेने को उतले 16 16 ने बीतले हाँ 16 refers to the order dated 16/3/2026 and 26/3/2026 to submit that. Since then, the petitioners have been taking time for the appellants. The appellants have been taking time for substitution of the legal heirs of respondent कितने से?
Respondent number
4.
3 and 4.
Respondent number 3 and 4. 12. Accordingly, the matter shall be listed for orders in the week commencing Satish Sathe. The learned counsel for the appellant is apprised of the fact that no further adjournment shall be granted, as no efforts are being made for the last for more than three months to file the substitution application, and the matter is kept pending for the last 11 years. Yes, next.
Item 3.
Mr. B.K. Mahanti for the Mr. S.S. Rao along with senior advocate along with Mr. B.K. Mahanti for the petitioner.
The assignments, your lordship dated 27/2/26, also directed to put this matter assignments. And a procurement of paddy.
Procurement of paddy, my lord.
Upon order करतले 27/2/26 order देखो. 27/2/26.
The learned counsel for the petitioner as well as the learned ASC for the opposite party refer to the order dated 27/2/26. তারপরে কিছু অফিস নোট আসছে কি?
Your lordship directed to the assignments.
And submit that the matter pertains to procurement of paddy and is not within the determination of this bench. Stop. The registry shall do the needful to find out the assigned bench for listing of the matter. Yes, next.
Item 4.
Your Lordship, I am behalf of SK Nanda. I pray for adjournment.
What's your name, madam?
Soumya Sucharita Pradhan.
Sorry, kindly.
SK Nanda. I am behalf of SK Nanda.
No. You have to tell your name. Unless you are having the power here, I have to mention your name.
No power. Soumya Sucharita Pradhan. Soumya Sucharita Pradhan.
Sucharita Pradhan. Ms. Soumya Sucharita Pradhan on behalf of SK Nanda for the petitioner. The matter was presented before this court on 20/6/2022. Thereafter, when it was taken up for fresh admission on 29/6/2026, adjournment was sought for on behalf of the petitioner. Thereafter, it was again adjourned on 27/2/2026. On 23/3/2026, the matter was heard at some length. The facts as well as the propositions of law were noted in the said order. And at paragraph 4, the following was directed. Paragraph 4. Stop. Thereafter, the efforts of the petitioner to adjourn the matter continued as it was adjourned on 16/4/2026, 5/5/2026. Stop. Today, the matter being listed for fresh admission. Again, adjournment is sought for. Apparently, the strategy of the petitioner is to adjourn the matter for the last more than 4 years after filing the revision application. To grant further opportunity, adjournment is granted reluctantly. The matter shall be listed for fresh admission in the week commencing.
Satish
Sathe, 20 आज सब जगह सतीश साथ करदेले सतीश तो 90टा 100टा आपण कर सके तो वीक कमेंसिंग 3/8/20 आपण केते डेट कोथिले 1 week एक्चुअली कोइ ना matter shall be listed in the week commencing 27/7/2026. Copy of this order shall be forwarded to the learned judge family court Sonpur to be kept in the records of the criminal, this case number 4 of 2021, disposed of by judgment dated 16/4/2022. The learned judge family court shall furnish a report regarding any execution arising out of the said disposed of miscase, criminal miscase. And if any execution is pending, the status of the same to the registry of this court, the report shall be tagged to the case record. Stop. Yes, next.
I
Mr. Manos Kumar Chand for the petitioner. Other side. Yes, please.
Last order. Last order.
Yes.
My lord is directed me to file, give a sum of rupees 1 lakh to the wife.
Coordinate bench has direct. Yes.
And I have complied. And then also admitted by the concerned advocate for the opposite party. That is order date 12/11.
The delay has been condoned.
Delay has been condoned and thereafter 12/11/2024, para 5 paragraph C
Yes.
of the order. So para 6.
6.
Yes. So that's the regarding acceptance of supplementary. And in the meantime, much more development has been there. In the meantime, divorce has been allowed, subject to payment of permanent alimony of 10 lakhs. And I have already paid the total amount. It was formally listed for final disposal.
He was in a hurry to marry in this year because this year they say there are no tithi beyond July 8. It's very unusual to not to challenge permanent alimony and.
No, they have accepted. They have accepted.
That's good. It's in lighter vein because you have been too serious.
Paid the entire amount. You have paid the entire amount.
Hopefully, this will not survive.
Yes.
Mr. Manos Kumar Chand for the petitioner. What's your name, madam?
S. Priyadarshini.
Mr. Lalatendra Samantara, senior advocate, along with you don't have power, file your power. Miss S. Priyadarshini for the opposite party. It is submitted by the Learned Counsel for the petitioner referring to the order dated 14/2/2023 as well as 12/11/2024. That as directed by the coordinate bench, taking up the present revision application, he has complied with the direction of payment or direction for paying rupees 1 lakh to the opposite party wife in the marriage. Stop. It is submitted that there has been further development in as much as the parties have the marriage between the parties has been dissolved by grant of decree of divorce by the Lord Judge Family Court, Punjab in
CP number 317 of 2017.
CP number 317 of 2017. Judgment dated. Judgment dated. Judgment dated as the permanent alimony amount of rupees 10 lakhs awarded. 48 purchase. The permanent alimony directed to be paid to the wife has been deposited. It has been received, Mr. Chan.
On 7/4/2020.
Permanent alimony of rupees 10 lakhs as directed by the said judgment granting divorce has been deposited by the husband, which has been received by the wife opposite party on
7/4/2025.
7/4/2025. The Learned Counsel for the Learned Instructing Counsel seeks further time to obtain instructions in absence of the Learned Arguing Counsel. The matter shall be listed for orders in the week commencing. Maybe Ms. Priyadarshini, this will not survive. And unnecessarily, this matter for the last 4 years is kept pending. Because 22, there may be a situation where the husband was agreed, but somehow he has at least beyond 10 lakhs also, he has paid this 1 lakh. You must consider his conduct. So to obtain instruction accordingly. Okay. For orders in the week commencing? 3/8. Sufficient time diya close this. Liberty to mention. Upon mention kali close age. Yes.
Item 6.
So Sushanta Kumar Sahoo for the petitioner. Opposite party blank. The petition has been filed by the husband in the marriage seeking a transfer of CMC C.M.C. into bracket PWDV number 13 of 2025 pending before the learned JMFC -com -NGN NGO Gramian Adhikari NGO. Mr. Chand, what is NGN? Gramian Adhikari NGN to full form. N capital, G capital, N capital. Grammar तो G है ना? अच्छा न्यायाधिकारी नाम ग्राम्य न्यायालय. Yes. JMFC -com capital N capital G capital N. Dunguri Pali to the court of learned SDGM Sambalpur. Earlier adjournments were granted to the petitioner as sought for on 24/12/2025. 7/5/2026. Today the matter being listed for fresh admission is mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding. Memo of date is filed which states thus. Into bracket SIC लिखित भूलभाल English सोचिए. The memo shall be taken on record, scanned copy be updated. The petition is disposed of accordingly. Yes, next.
Item 7.
Mr. P. Jati. Yes, please. Mr. P. Jati, Mr. Gautam Kumar Acharya, senior advocate, along with Mr. P. Jati for the petitioner, opposite party blank. The learned counsel for the petitioner submits that the order dated 19/5/2026 was somehow not uploaded in the official website of this court, and he seeks for the time to file an affidavit in terms of the said order. The office is requested to verify the uploading and upload the order if not already uploaded. Stop. The matter shall be listed for fresh admission in the week commencing. How much time, Mr. Jati?
After 10th August, Lordship.
ठीक है. It shall be listed in the week commencing 10/8/2026. Affidavit be filed by 3/8. ना आवरी earlier file कर परियो.
By next date, Lordship.
Let me check the order also whether it is there in my. Yes, it is there.
Yes.
Affidavit be filed could लिखा है. Para
Last.
6. Para 6. Shall file affidavit. Okay. The affidavit as directed at para 6 of the order dated 19/5/2026 shall be filed. आज हो चुकी कितनी तारीख? 2 तारीख. Filed by. अरे आप senior नॉरेल अपन तो करीबे ना. So prepare the affidavit by 30/7/2026. Sufficient time is given.
Lodge.
Yes. Yes, next.
Oblige.
Item 9.
The Santanu Kumar Chodaki, senior advocate, along with Mr.
Adi, along with Sir Nahant.
Nice, sir. 70 sign, 70 no, sir. That's there is a Advocates Act. We have to. We can't mention you to be appearing. So.
SK Sodangi sir koi diyo. Along with.
ठीक है, Mr. SK Sodangi. Yes.
Sir, एथिरे already हमें.
How many Sodangis apart? Sudeep is there.
Sudeep, Siddhant.
Siddhant. How many other? Only Sodangis. So then I have to record that in absence of the Sodangis. Yes.
Sir, एथिरे.
ସେତେବେଳେ ଆପଣ ଗୋଟେ adjournment order ହେଇଥିଲା.
Adjournment order ହେଇଥିଲା certificate proceeding ଟା. In the meantime, the Lordship had not opined, observe, can challenge colony order ଟା କଣ?
That was a part of discussion.
Not observe what I said. So in the meantime, we approached the Honorable High Court. Honorable High Court is in session of the matter 4th August to ଆସିବ High Court ର matter ଟା.
ଆପଣ ଏଟା pending ରଖିବେ କହୁଛନ୍ତି?
Pending ଏଟା ରଖିବି.
ଠିକ ଅଛି. Yes, Mr. Mohanty. ଥାଉ. Challenge ହେଇଛି ଗୋଟେ proceeding pending ଅଛି.
Meanwhile, we'll file counter.
କରିଛନ୍ତି କରିବେ
ଆସିଗଲାଣି ପରା କହୁଥିଲେ।
No, no, no.
ନାଇଁ, ଆପଣ Mr. Mahanti, I
I am
think
sought for instruction.
I think I mean the better strategy, though it is not beyond my it is beyond my domain also,
No, no.
but the strategy would be that ଆପଣ main case ରେ କଣ ହଉଛି watch କରିବେ ତାପରେ ଏଠାରେ counter fail କରିବେ ନହେଲେ conflicting ହବ ସେ ଏଇ counter ନେଇ ସେଠି ଦେଖେଇବେ. You must understand the Mr. Senior. It is submitted by the learned senior counsel appearing for the petitioner that during pendency of the present writ application, ଆପଣ ଯୋଉଟା ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି that
ଏନଜିଟି ଅର୍ଡରଟା ନା ଏଠି ଆପଣ ପାଖରେ ସାର୍ଟିଫିକେଟଟା
got sir, but ଆପଣ ଯୋଉଟା other cases କରିଛନ୍ତି
ଏନଜିଟି ଅର୍ଡର
the order dated 22/4/2025 passed by the learned National Green Tribunal Eastern Zone Bench Kolkata in original application number 150 देखी लिख परिबे तो तरबरे डाकी दोची order dated 6/3 रे para 2 रे अछि और original application number so and so 153/2023 oblique capital E capital J has been challenged by filing writ application
9565 of 26
9565/2026
9565
9565 of 2026 WPC number 9565 of 2026 which is pending adjudication before the division bench.
Sir.
Before
No,
the
sir, before the single bench.
Before the assigned bench. Before the assigned bench. And is posted to 48/2026. It is submitted that in fairness, this matter should await the other writ application and maybe adjourned.
କହୁନି ମେ ମୁଁ ମେ କହିବି ନା ମୁଁ କଣ ସୁଡ୍ କହିବି
ନା ଆପଣ ସୁଟ୍ କହିବେ ଚଳିବ you can you have
ମୁଁ କହିପାରିବି
the matter needs to await the order the await say part to jiban the matter may be adjourned in view of the pendency of the challenge to the order of the NGT
sir
the learned NGT stuff. The learned additional standing counsel submits that he shall obtain instruction. Accordingly, the matter shall be listed for fresh admission in the for orders in the week commencing 4/8 कहले ना
4/8
week commencing 10/8 ना 17/8 week commencing 17/8/2026. Yes.
item 10 22 नंबर बोधे लंच पर पड़िबो
ले आज कोन absence आज तो
ମୁଁ ଦେଖୁଛି ସାର୍ ନହେଲେ I'll take it
No
or else
difficult.
maybe
Yes, please.
The house can
I'm sorry, Mr. Nath, I lost the number. Code number ta kahile? 10. Yes.
Already compliance petition has been filed. Compliance petition has been filed. Compliance date has been filed from 11/2/2025. Copy
Just kindly look at the order 1/5 order ta dekhon. Mr. Amit Kumar Nath for the petitioner. Mr. Prem Kumar Mahanti, additional standing counsel for the opposite party. Stop. देखिए Mr. Nath file है ना? Yes, please. 1/5. Lord and additional government advocate refer to the show cause affidavit. Just read that. Can read it aloud.
Yes, ma'am.
Lord and additional para 2. Just read it aloud. Have you got it?
I have not got it, madam.
Then it's
Madam, he's highlighted. Yes, highlighted. So delete the name of delete the opinion one, madam. Content for one. First, para 3 in view of the affidavit, find and the fact that on 19/12/2020, when the order was passed of the first date of dispute by the coordinate bench, the opposite party industry department was not the administrative department. The present applicant is draft against copy number 1. To grant further opinions to the petition, list of fresh addition in the week comments.
ତାଙ୍କୁ କାଇଁ ପାର୍ଟି କରୁଛନ୍ତି ଆପଣ ଯୋଉଟା ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ଡିପାର୍ଟମେଣ୍ଟ ତାକୁ ପାର୍ଟି କରୁନାହାନ୍ତି
Yes, madam. Yes, copy so that I had.
ପାଇନାହାନ୍ତି କପି
This Woko's
the Learned Additional Standing Counsel refers to the affidavit, the order dated 152026, wherein at paragraph 3 the following was observed. Para 3 and 4. Yeah, quote corner. The Learned Counsel for the petitioner submits that he may be provided with the Soko's affidavit filed before this court. Copy of the Soko's affidavit is served on the Learned Counsel for the petitioner. Stop. The matter shall be listed for orders in the week commencing.
Day one thing, madam. Some petitioners have already granted a benefit by this and the court order. In the sworn court order. That is only instructing about the matter regarding the order.
Hey, upon a quasi criminal proceeding, when you do not make the proper party, the entire proceeding goes. Please appreciate that. Because we are at a threshold that proper party is not made. So अपन जहाँ पार्टी करिया कथा करंतु but other side को notice जाइछि ना जाइनि
Yes.
से कोडे गले
Team other principals.
से कांति डायरेक्टर एंड रजिस्ट्रार आपण देखंतु सेटा तापरे बर्तन आई थिंक दैट हैज बीन बिकम ए यूनिवर्सिटी आल्सो कोन हेतु आपण सेटा आपण चेक सो वेदर दे हैव अपीयर्ड और नॉट यू चेक इट बाय द नेक्स्ट डेट he is not appearing for them.
Yes.
When you are saying that I am direct in their absence, because I have not checked whether they have appeared or not.
There is something that matter makes. But some restrictions are already.
It cannot be. For when they are not before me and they are not governed by the OP number 1, how can it be? It is in your interest to make the proper party. Okay. List for orders in the week commencing. Satish Sate. Yes, next.
That's it. Green order that previous
item 9.
A 9 elective entry order dated so and so shall is reiterated. The pending proceeding
beyond 79.
So and so that shall be adjourned to a date beyond 17/8/2026 as will be convenient to the concerned authority, convenient to the authority in season of the matter. Next.
11.
Mr. Asit Kumar Jena for the petitioner.
DN Lekam.
Sorry, sir.
DN Lekam.
11 Mr. DN Lenka. DN Lenka HGA for the opposite party state.
Lordship, may kindly have a glance to order dated 21/5/2026.
Yes.
And my lord, the report submitted by the learned session judge.
Just let me go through that. ट्रेल कौन लिखछन ट्रायल को ट्रेल लिखा है कोन
से भूल ही ऑर्डर तो
समस्त आगे एते भूलभाल होची ताकू सेतोले मु पढिला बेले ताकू ट्रायल पढिची देखला बिषय ट्रेल लिखा है TRAI है
मैं देखि
मितो ग्राउंड होची मैटर रे ताकर आर्ट है मैटे Accident भी precedence है जी बहुत अच्छी. Mr. Jena, you can just look at the paperless. Can you do you use that?
Yes, ma'am.
You should use that.
Yes.
It's meant for you only.
Yes, ma'am.
Because this one, Mr. Mahanti can see because he is the prosecution. Or both of you can see together. Flag B रे अच्छे छेड़ा.
Flag B टा आसु नहीं है.
जे जान जो अपन को पढ़े ले. ता सेटा ताकर दिया नहीं. आया. सबुतिर अच्छी. এটা হচ্ছে টিআরপি সিরিয়াল 31 মিস্টার কনসুমার 31 of 2026 লাস্ট হচ্ছে ফ্ল্যাগ বি তারপরে সাবমিশন অফ রিপোর্ট রিপোর্টর পেজ 2 রে যাতো ফার্স্ট ଅଛି ফার্স্ট পেজ
Test 2.
जेडी क्रम जेएमएफसी पेज 2 रे লেখা দেখো তো থার্ড সবপারা 2 ଅଛି.
Yes.
This further submitted that the necessary inquiry was made with the court ASI and dealing assistant attached to the complaint case section, and the case record was perused. It is found that till date no complaint, report, or information has been received from the informant, witnesses, or any other person arising threat, intimidation, or any interference with the fair conduct trial. It is also submitted that pursuant to the aforesaid order of Hon'Ble High Court, the court has intimated the inspector in charge, Hon'Ble Police Station, and learned public prosecutor Nagar to furnish reports regarding whether any complaint, report, or information had been received concerning any threat, intimidation, interference with the fair conduct of the trial by the accused person of them. Yeah. Whether the victim, informant, or any of the charge-sheeted witnesses sought protection under any witness protection scheme upon receipt of the compliance report from the aforesaid authorities, copies of which are enclosed herewith. From part of this report, it is found that no such complaint, report, or information has been received by them till date. As for the reported, neither the victim nor any charge-sheeted witness sought for witness protection. And in view of the above, upon perusal of the case record, inquiry made through the concerned court staff, concerned reports received from the inspector in charge, Hon'Ble, public prosecutor, learned public prosecutor Nagar, there is presently no material before this court to indicate any obstruction for free and fair trial. However, if any such complaint, information, request for protection is received, appropriate steps shall be taken in accordance with law by this court. So you can seek, still then you can seek for a witness protection, but it can't be transferred. There is nothing on record to transfer it.
Yes, ma'am. Your lordship may kindly have a glance, my lords. Section 407, clause C, my lords.
CRPC you are referring?
Yes, CRPC, then my lords, the BNSS.
No, that I have quoted.
Yes, your lordship has quoted, and my case has been, my lord, coming under this, my lords.
407?
407, clause C, my lords. May I read, my lord?
Just 1 second.
Yes, ma'am.
I'll get there.
Yes.
Four 407 of CRPC.
CRPC, my lords. Clause C.
That an order under this section is required by any provision of this code or will tend to general convenience.
Yes, convenience of the parties or witnesses or is expedient for the ends of justice, my lords. So here, this is a case, my lords, that total 5 witness charge-sheeted witnesses.
That Mr. Jena have considered.
Yes, your lordship has considered, my lord.
I have said that that cannot be a ground. So that.
But
that
there
I
is a
cannot
provision,
change.
there is a such
There is a
provision, my
provision,
lord.
there is a provision. I'm rejecting. You have to test my order.
No, no, no.
I cannot keep on changing every day. Today I say that convenience of witnesses staying at Cuttack, it should be at Cuttack. So that I do
And
not
that
agree
is
to
the,
that.
that is the law, your lordship, my lord.
No, that's not the law.
Yes, my lordship, may kindly see, my lord. And your lordship also,
You see,
and your lordship also.
Mr. Jena,
Yes,
it's
my
very
lord.
simple. You are adding those words. You are adding that because all the place of residence of the parties.
Yes.
Witness, it is not there.
No. Residence of the party, no, I am not adding, my lord. Your lordship, I'm reading again.
So that I have noted.
Your lordship has noted.
Just look at that.
Your lordship, kindly see your lordship.
Para 3.
Yes, my lord. To support of the.
No, you argued well. You argued well that point. That is, I have noted that. It's
yes,
not that you have not made that point.
Yes. Then also your lordship, kindly.
Regarding the witnesses 1 to 5, just mark that. It is submitted that all the witnesses belong to Cuttack. Witness number 6 belongs to both. He submits that since all witnesses belong to Cuttack, the matter should be transferred to Court of Learned Decision Cuttack.
Yes.
So that I do not agree. That where they reside, it has to be the place of trial.
Because of the convenience, your lordship.
That I do not agree, sir. I do not agree because those words I cannot find because where the parties witnesses stay, that is the most convenient place. Those words are not there.
Convenience of the, my lord, the witnesses is concerned, my lord.
Yes.
Convenience was not for the place, my lord.
Wherever the witness is, even it's like you find official witnesses, they are throughout the state. So they have to call, they will get bata or whatever they're getting.
And that this is not like that case, my lord. This is a case, my lord, purely your lordship, my lord, consider the point, my lord, the informant herself is a, my lord, lady. And my lord, there is a threat perception is also there.
So for that reason, I had, considering that only, I had tried to, what you call, not exact, initiate something which can happen. So she may seek for witness protection.
Your lordship may kindly, my lord.
Because I cannot assure that Cuttack is safe, Noyagarh is unsafe. That has to be there. And that is how a detailed report was furnished if she is at all being threatened. Because you said that she is a lady, she is, she may not feel comfortable in approaching.
No, she is also under threat, my lord.
Exactly. So that has been investigated.
That was not investigated. What the report said, my lords, that I have not given any complaint before my lord.
You have to do that.
Yes, my lord.
Because you see, there is no law enforcement agency which will go to the person and say that, have you received any threat? No. The law enforcement agency cannot seek this report from anyone.
Na se reporter kahile.
So at least the purpose was what you have achieved. They have been sensitized. In our system, you find that many marginalized persons who are not that well educated or being a lady, they are not taken care of. So at least you have sensitized them. So they have been asked this question by the court that whether there is any threat. So they will be now sensitized. And if you want witness protection, it will be granted. I don't know. By law, it has to be granted by the court. That much at least you have achieved. The entire system was sensitized by your efforts.
Supposing, my lords, I have been protected. I am one of the, my lord, the witness, my lords. The rest 4 witnesses are also there, my lords.
I cannot, the court cannot take the way you are interpreting the most convenient place of residence or the most convenient place for the witnesses.
Here, your lordship, for a moment, my lord, here my point is 2 points, my lords. I am and the witnesses are under threat, my lords. That is coming under, my lord, the 407 clause 1, my lord.
Mr. Jena, the difficulty is that this court cannot presume that unless the system takes care of it. Suppose a crime is happening. So, is every crime is investigated?
That is, my lord.
Not that is, my lord. That is the precise answer. You know it.
But this is a field case, my lord.
Only those crimes are investigated which are reported.
Yes.
By FIR or maybe report of the police itself, like riot, accident, all those things. The police itself. In NDPS in so many cases, seizure. The police SI still, he being the investigating person, he still prepares a report.
Yes.
So that cannot be that. There can't be any presumption that every crime has to be investigated unless report, even if it is not reported. It is not law actually.
And my lord, in fact, my lord, your lordship, may I kindly see, already charge is submitted, my lord. Only trial will be conducted for the purpose of, my lord, examination of the, my lord, 6 witnesses, my lord. And as I, my lord, ever in my
Mr. Jena, no witness is privileged not to travel to the court. Because I'm thinking in those lines.
Yes.
Because I'll be, as you said, that I have to create a precedent. I'll be creating a precedent that convenience of the witness, because every witness is traveling throughout length and breadth of the country,
yes, my lord.
as you find nowadays, because there is migration of official witnesses. They retire, they go to Bengaluru, they go to Kolkata, they go to Delhi. They are summoned.
But that
You can avail the, if it is possible, like vulnerable deposition center or whatever. Those things, those are part of it. At least you have achieved that. They have been sensitized of that. And witness protection also.
Yes.
Beyond that, I think that there is nothing. I think that at least you have achieved that, so that will
Lords,
satisfy you.
ଆପଣ ଚାହିଁଲେ କରିପାରିବେ.
Fine.
Because points are there, my lord. If the points are not there, my lord, I should not, my lord, pray
Mr.
for the
Jena,
transfer. my
your
lord.
perception of your means not the lawyer. Your
Yes.
perception of feeling threatened cannot be translated to court's perception.
Not only the threatened, my lord. Not
You
only
have to-
threatened, my
you
lord.
have to- You have to commit. You have to be committed to your cause. You have to, inform the law enforcement agency, the court, public prosecutor. The
Why
court side.
I have not
You have to do
intimated,
that.
my lord? I have, my lord, ever in my petition, that is para 6 and 7, and your lords will
That you
quoted
state
that, my
there.
lord.
That you state there. You see what is happening. Your apprehension being threatened has to translate further action. Simply saying before this court, at least you have achieved that. The entire process, entire system has been sensitized. Not only the magistrate, learned magistrate, he has gone to the length of asking everyone, all the stakeholders, so that maybe your apprehension is that the prosecution is not protecting you.
Yes.
The prosecution is favoring the accused persons. So those things have been sensitized. I didn't elaborate when I said that.
My lord, I understood what your lordship is.
You have achieved something, and it is because of your efforts only. Only because you persuaded the court to ask these questions to them. Otherwise, these are not the routine things. These are judicial orders.
Then matter may be adjourned, my lord. In the meantime, my lord, I will apply before the, my lord, the competent authority for the witness protection, my lord.
You go ahead. I'll observe that today.
And your lordship may direct, my lords, that if I am filing any application before the competent authority for witness protection, my lords, they will take necessary step immediately.
Can there be a presumption after this kind of exercise has been done by this court in partly in judicial side, partly administrative side? It has to be considered.
Judicial, your lordship, judicial will more effective than, my lord, this.
So, Jena, they are in a unenviable position.
I'm agree, my lord, with your lordship.
How can I presume that they will not act?
Your lordship will die.
I will observe that it will be dealt with in accordance with law. That much.
In accordance with law, if your lordship is not directing, my lord.
You are too skeptical about the judicial process. That cannot be. As a lawyer, you should be more optimistic.
No, my lord. In accordance, they are interpreting, my lord, in accordance with law, they are interpreting in various manner, my lord. That is the whole difficulty, my lord.
You are yet to file that. Did I blame you that I have not filed? I could have easily. Still, then I am not saying that.
ସେଇଟା କରିଦିଅନ୍ତୁ
ଆପଣ ତ କରିନାହାନ୍ତି ସେଇଟା
ମୁଁ କରିବି ବା
ଆପଣ କଲେ ଯାହା ହବ ସେମିତି କରନ୍ତୁନି
ତାହେଲେ ଆଡଜର୍ନ କରି ରଖିଦିଅନ୍ତୁ ମୁଁ କରୁଛି
ଆଡଜର୍ନମେଣ୍ଟ ଆଉ ଦେଇ ହବନି ଦିସ୍ ମ୍ୟାଟର୍ସ କ୍ୟାନଟ୍ ବି କେପ୍ଟ ପେଣ୍ଡିଂ ଆପଣ ଯୋଉ
ନା ମୁଁ ପେଣ୍ଡିଂ କେବେ ଯାଉ ନାହିଁ
ଟ୍ରାଏଲ ଇଜ ସମହାଟ
ଟ୍ରାଏଲଟା ମୋ ଫୋର ହେବ ଆଜ୍ଞା ମୁଁ ଆଇ ଏମ୍ ଭିକ୍ଟିମାଇଜ ମାଇ
ଯାହା ବି ହଉ ଟ୍ରାନ୍ସଫର ପିଟିସନ କ୍ୟାନଟ୍ ବି କେପ୍ଟ ପେଣ୍ଡିଂ
ନାଇଁ ପେଣ୍ଡିଂ ରଖନ୍ତୁ ନାହିଁ ଅର୍ଡର ପାସ୍ କରିଦିଅନ୍ତୁ
ୟେସ୍ ଇଟ୍ ୱିଲ୍ ବି ଟେକେନ୍ କେୟାର ଅଫ୍ ଆପଣଙ୍କ ଆଂଜାଇଟି ତ ଆପଣଙ୍କ ଆଂଜାଇଟି ପାଇଁ ତ ଏତେ ଲମ୍ବା ଅର୍ଡର ହେଇଥିଲା ଏବଂ
ମୁଁ ଆଜ୍ଞା ଲେଡି ଲୋକଟେ I have been cheated by the, my lord, the accused persons, and he has lost.
Magistrate ହେଲେ ମତେ କହିବେ. So right now I am not hearing your.
ମୁଁ ସେଇଥିପାଇଁ
ଆପଣଙ୍କର ବହୁତ ଭଲ କେସ୍ ଯୋଉଟା ସେଟା I cannot pass a order in your very good case. Can I convict them?
No, that is why, my lord.
So let us spend our time wisely. ଆପଣ ସେଠି ଆର୍ଗୁମେଣ୍ଟ କରନ୍ତୁ ଏବଂ ଜିତନ୍ତୁ. Assist the public prosecutor, whatever way. The learned counsel for the petitioner is again hard at length. Pursuant to the order dated 21/5/2026, report has been received from the learned A.C.J into bracket JD-com-JMFC Hon'Ble. The report contains the steps taken by the learned judge as well as other relevant aspects of the pending trial and is reproduced herein. On perusal of the case record, class B achieved up to copy of the letter dated PP Noyagar. Para. The learned counsel for the petitioner again reiterates his submissions referring to sections 407 of Criminal Procedure Code 1973.
Along with
407 bracket small c, since repealed and substituted by perimeter provisions contained in section 447.
C.
See, same
C. Khali
447
C.
bracket 1 into bracket small c. Stop. Para. It is submitted that the general convenience of the parties or witnesses would mean that the trial should be held at the place where the witnesses reside. In considered view of this court, the said proposition as the said interpretation, the said interpretation by the learned counsel is not in accordance with the language used in the section. That is, general convenience would mean that the trial should be at the place where the witnesses reside. This court is not inclined to grant the prayer for transfer of the trial pending at pending before the learned JMFC, learned so and so to put a lecture in JMFC Hon'Ble to the learned STJM Qatar. Apart from the said aspect, apart from the issues raised by the learned by the petitioner in the present application, it has to be noted from the report of the learned case A.C.J into bracket JT -com -JMFC that the learned court has taken up the matter with due diligence and in accordance with law. The petitioner, if so advised, may seek witness protection under the witness protection scheme, which shall be dealt with in accordance with law. The petition is disposed of. Yes. Sir, this order is अत्यधिक. ଆପଣ ଫାଇଲ କରିବେନି ମୁଁ ଖୋଜି ଲୋଡ଼ିକି ବାହାର କରିବି ଯେ କରିଛନ୍ତି କି ନାହିଁ 5 ଜଣଙ୍କୁ ପିପି କୁ ପଚରା ହେବ ପିପି କୁ ବୁଝି ପାରୁନଥିବେ ହାଇକୋର୍ଟ ହଠାତ୍ ମତେ କଣ ପଚାରିଲେନି କି ଥ୍ରେଟନ୍ କରୁଛନ୍ତି
that I understood my lord.
ସୋ ଆମେ ଆପଣ ବହୁତ ଜିନିଷ ଆଚିଭ କରିଛନ୍ତି so you should be satisfied with that.
Only one line may be added, my lord.
ଆପଣ whatever sir it let us avoid predictive orders.
ମୁଁ ଖାଲି କେବଳ ସେ ଲେଡି ପାଇଁ କହୁଛି ନା ଅଲଗା କେହି ହେଇଥିଲେ କହି ନଥାନ୍ତି।
ଆଜ୍ଞା ଶୁଣନ୍ତୁ ଆପଣ ଯୋଉଟା କହୁନାହାନ୍ତି the judge is a lady, the PP is a lady, the IS would be a lady. Don't portray them as a very helpless and helpless creatures.
ସେମାନେ ଆଜ୍ଞା ବହୁତ ଉପର ଜାଗାରେ ଅଛନ୍ତି।
ଉପର ଜାଗାରେ ଅଛନ୍ତି ସେ ବି ଆପଣଙ୍କ ଭଳିଆ don't underestimate the women's power.
No, I am who am I to underestimate my lord?
Thank you.
Deep love.
And appeals for the petitioner when the matter is called. Matter shall be listed for orders in the to grant further opportunity shall be listed for orders in the week commencing
10 year,
3 থেকে 2024
17,
same order.
nineteen,
And it's a mention କରିଥିଲେ ନା
ଆଜ୍ଞା।
ତା ନାଁଟା ମନେ ଅଛି
ରବୀନ୍ଦ୍ରନାଥ ପୃଥ୍ୱୀ ତାଙ୍କ ନାଁ
ନହେଲେ ଆସୋସିଏଟ କଲାଟା ମୁଁ ବି ପଚାରିବାକୁ ପଡିବ ଠିକ ଅଛି So Rabindranath Prushti for the petitioner opposite party black. The Lorry counsel for the petitioner was heard on 6/4/2. ଆପଣ ଏମିତି କରିଦିଅନ୍ତୁ 6/4/2026 ଲେଖନ୍ତୁ 6/4/2026 ତାକୁ ରିପିଟ୍ କରିଦିଅନ୍ତୁ 1 2 3 and 1 2 ପରେ ଲେଖିବେ After hearing the counsel for the petitioner on 6/4/2026 the following order was passed. Then reproduce para 3 and 4. 3, 4, 5. 3, 4, 5. Matter was thereafter adjourned at the instance of the petitioner on the Judiciary Kude Chabisi. Stop. Today, the matter being in the list is mentioned by the Lord Counsel for the petitioner. Stop. He files memo of date which states thus. To bracket SIC. Who shall be taken on record, scan copy be updated, the petition starts this. So, petition is disposed of accordingly. Is disposed of accordingly.
21,
Mention correctly.
ନାଇଁ sir,
What was mentioned? Petitioner none, opposite party none. The matter is listed for orders and is adjourned to grant further opportunity to the petitioner to be listed on for orders.
we commencing 3 year,
Commencing TNAT.
22,
Mr. Antonu Kumar Solanki, senior advocate, along with Mr. Sudeep Kumar Solanki for the.
My please, lords.
This bench has jurisdiction, এটা determination ରେ ଅଛି ତ? Roster ରେ ଯୋଉଟା
ହଁ ସାର୍ ଏଟା ମୁଁ ସାର୍ଟିଫିକେଟ ପ୍ରୋସିଡିଂ ଏଗେନ୍ଷ୍ଟ ଆସିଛି
ଆଚ୍ଛା ଆଚ୍ଛା.
May I please, my lords.
Yes.
Annexure 1 is the order of the real estate regulatory authority.
Yes.
There, my lord, I was at expert and the sum of rupees 15 lakhs has been directed to be paid along with interest 9.5% from 27/8/2018 till payment. Your order will find the operative part at page 13.
Yes.
My lord, pursuant to this, in terms of the orders, in terms of the provisions of the Orera, my lord, the matter has been sent to certificate officer for realization of this amount.
Yes.
Because obviously I didn't pay the dues. My lord, so the provision says section 40 subsection 2, if any adjudicating officer or the regulatory authority or the appellate tribunal, as the case may be, issues any order or directs any person to do any act or refrain from doing any act which is to be empowered to, which it is empowered to do under this act or the rules or regulations made thereunder, then in case of failure by any person to comply with such an order or direction, the same shall be enforced in such manner as may be prescribed. Now, prior to that, in subsection 1, it shall be recoverable from such promoter, LOT or real estate agent in such manner as may be prescribed as an area of land revenue. So pursuant to this OPDR proceeding has been initiated and rules governing this is, your lordship, my lord would find rule 26.
Also, real estate regulatory.
Rule 26. Now, lordship need not look at that because this is the standard procedure.
Yes, yes.
The subject to the provisions of section 1 of section 40, jota sir kahili, the recovery of the amount due such as interest, penalty or compensations will be recovered as land area of land revenue in the manner provided under the OPDR Act, Odisha Public Demand Recovery Act, or Act 1 of 1963.
Yes.
Pursuant to this, the order was sent to the authorities concerned, the certificate
You
officer.
have not challenged the order of ex parte, though it is ex parte, but you have not challenged that.
This order of the appellate, original order has not been, as my instruction is so far not challenged.
Then what was your stand in that OPDR Act, section 8?
Sir, mote dei nahanti. Opportunity diya hai. That is what I am questioning in this writ.
How do you say, do you have the copy of the order sheet in the OPDR proceeding?
No, sir, ani nahi. Annexure 2 type, your lordship, you look at a moment at page 14. Whereas you have failed to satisfy the certificate dues of 9 of 24 arising out of execution case number such and such for rupees 23,69,217, it is proposed to execute the above certificate by arrest and imprisonment for your person. You are hereby required to appear before this court on 22/7/2025 at 11 AM and so cause as to why you should not be committed to civil prison in execution of the said certificate.
No, I think this is only part of the story.
Could be what your lordship is saying. From my experience also, I am saying this is not the entire facts.
Your petitioner actually is now doing the same thing. He's not granting you opportunity of hearing.
Sithir sir, what I am saying, I should get a problem that section 8 petition they be not they be.
The problem is that you do not know what has happened.
My instruction is so far as instructing counsel what he gave me, that my lord kichi au hei nahi. Apart from this notice.
Because these administrative authorities, they go by the book. But the problem is your petitioner has all the problems not intimating or appraising the lawyer.
Except this notice.
Anyway, so in fact, no one is there to represent them. So you take.
Lordship, I'm appealing for the real estate authority first.
So,
copy of the writ petition may be served.
No, statutory authority need not be noticed because you are not supposed to defend your order.
Please,
that should be your. That is my understanding.
Please,
I cannot go to Supreme Court to defend my orders. I should not be a party there unless
we have
that kind of extraordinary situation. No, you will be made a party because the records are necessary or register.
Only humble prayer is that copy may be served. We may enter our appearance. We will not defend our orders.
No. Why you are disturbing? Is there any order passed? You suddenly run to the court and start saying something.
No,
please be patient.
Please
be more patient than your client also.
I bow down.
So please listen and participate in the proceeding. So who is saying that you will not be should notice? We are discussing something else.
Sir, your lordship is aware of notice form A, form B, segula so assess those things.
Everything. And there must be some record whether you responded to section 8 or not, or what was your stand and how it has.
Whether I have at all I have taken a stand or not. If not, then it goes, and that is why I am before your lordship, or else ordinary.
No, because you saying so cannot be substantiated because you have not. I mean, there is nothing on record to show that. Suppose you have obtained the certified copy of the entire order sheet to show something. Anyway, you take notice. The petitioner is a. It is a proprietorship concern.
Private limited. So Joy Santosima Infrastructure.
The petitioner is a private limited company engaged in real estate development. Is before this court challenging the certificate proceeding.
Number 9 of 24.
9 of 2024 under the Odisha Public Demand Recovery Act.
Sub collector cum certificate officer Bhubaneswar.
More particularly, the order dated, the notice dated
10/6/2025. Top रे sir.
10/6/2025 issued by the sub collector cum certificate officer Bhubaneswar. Directing for execution of the certificate. With a certificate number 9 of 2024 arising out of execution case number 49 of 2024 for rupees 23,69,217. It is submitted by the learned counsel, the learned senior, hard learned senior counsel for the petitioner. It is submitted that prior to issuance of notice at Annexure 2, notice dated 10/6/2025 into bracket Annexure 2, the petitioner has not been given any opportunity. Stop. The learned senior advocate, the learned senior counsel was requested to substantiate such submission by referring to any order sheet of the certificate proceeding. It is fairly submitted by the learned senior advocate that the order sheet of the certificate proceeding prior to issuance of the notice has not been annexed or provided. Stop. In such situation, this court cannot form an opinion that the petitioner has not been given any opportunity on the basis of bald statement made in the writ application. The learned senior advocate refers to the coercive measure directed by in the notice and submits that unless the petitioner is protected and the opposite party is not heard, the petitioner shall suffer irreparable injury, as the notice itself directs for arrest and civil imprisonment. Stop. Issue notice along with this order to the opposite party. Issue notice on admission, indicating that the matter is likely to be disposed of at the stage of admission. Sir, what's your name?
P. Naik. Balaram Naik.
Mr. Balaram Naik, learned counsel, submits that he has instruction to appear on behalf of the OP number 1 and shall file wakalatnama within
1 week.
Within 7 working days upon filing of wakalatnama. The same shall be accepted, scan copy be updated. Name of Mr. Naik shall be indicated as the cause list as well as the case in the cause list as well as the case brief. Then issue notice to OP number 2 by speed post with registration and proof of delivery. Widgets for issuance of notice be filed within 3 working days. Returnable date be fixed to 3/8/2024. The matter shall be listed in the week commencing 10/8/2024. Mr. Balaram Naik ko purbu likhibe the learned additional standing counsel upon advance copy served appears and waives notice on behalf of the OP number 3. Mr. Osman, you are appearing.
Your Lordship, but the
Copy not served.
is not served.
Mr. Sujit, you have not served copy.
नहीं सर कॉपी इंडिपेंडेंटली सर्व है ही नहीं.
अच्छा ठीक है.
Neither a file.
चेंज करे पड़ेगा. The OP number 3 sub collector from certificate officer shall be represented by the learned additional standing counsel. Let an extra copy of the writ application be served on the learned additional standing counsel by tomorrow. By tomorrow. Stop. सेटा करे तापरे आकु नोटिस करिवे. OP 2 को नोटिस करिवे. आइए issue notice as above, accept one set of process fee. The learned additional standing counsel as well as the learned counsel, Mr. Naik shall appear for the respective opposite parties as indicated above. extra copy of the IA shall be served as directed above. ଆପଣ କପି ପାଇନାହାନ୍ତି ପରା I'm sorry. ତାହେଲେ ସେଟାକୁ ସେଟା ବି ଆଡ୍ କରିବାକୁ ପଡିବ ବଳରାମ ନାୟକ ଯୋଉ ଲେଖିଲେନି ସେଟା ଆଡ୍ କରି extra copy of the requisition shall be served. Just like the additional study. As an interim measure, it is directed that the notice dated 10/6/2025 into bracket annexure 2 issued by the so and so in CC number certificate case number 9 of 2024 shall not be given effect to till the next date of hearing. Urgent certified copy shall be issued as follows.
May I submit my lord?
Please.
Copies to both by Monday, your lordship may say.
ठीक अछि within 3 move केते दिन कहली by tomorrow कहली within 3 working days.
तो नंबरটা ये
Item 23.
Requisites हवा ना 5 दिन तक है.
Requisite by 3 days, sir.
ठीक है रिक्वेस्ट जा 3 वर्किंग डेज अछि से कॉपी भी 3 वर्किंग डेज पर 21 ठीक है सर आपनकर एबे कोनटा कॉल करा हला एबे को अटेम्प्ट देखली 23 22 पर 20 आपण केते कहउछथि मिस्टर मल्लिक
21 lordship. I was absent at the time of all. And for the
21 जोड़ा का नॉन अपीयरेंस तक नॉन अपीयरेंस कैटेगरी सिंपली पोस्टिंग कर कोटा नॉन अपीयरेंस
21.
ते 15 टा को भी आपण सिंपली पोस्टिंग कर दियंतु डेट को डेट कहि दियंतु आथरे 15 आरंभ कर जोटा आपण डाकिथिले कर दियंतु
15 नॉन अपीयरेंस
नल की केतो आसे फेर एटा चालियो 15 टा डेट केबे करछ
3/8 वो कम 3/8
15 ऑर्डर किछ होगा 3/8 हेला पोस्टिंग जस्ट पार्टशिप वन आफ्टर अनदर
17 सर
17 क्या पेयर करछली 17 वाला तापरे 21 पिटिशनर अपोजिट पार्टी के अछन पिटिशनर नांती ठीक अछि 21 सेफ्टी किछ ऑर्डर करंतु पोस्टिंग कर दियो डेट कर दियो सुविलानी
वो कम से 3/8
आपण 3/8 आगुर चाहुचंदी
this month.
27
Your lordship, the petitioner had come a while before. He asked me the date. I told him 3/8.
Let's say ताकू 27 आपण को दायित्व आपण एटा क्रिएट करछन सिचुएशन अरे एवरीवन हैज ए लेग सर and no difficulty for to come in wheelchair also की आंसर गिव ए इंटेलिजिबल आंसर आपण नॉन अपीयरेंस हला आई वाज ऑन लाइक द अदर साइड आसी द डेट नहीं पळेले सो दैट यू हैव टू सॉर्ट आउट आपण तो फोन करिवे 27 बोली द नंबर कोड पाइबे yes next Mr. Pradhan Kumar Maharaj for the petitioner.
May I please, Lord?
Yes, please.
My lord, I am a small player, Lord.
Yes.
The farmers, my lord, for registration for procurement of paddy, Rabi crops for the year to
Procurement ta more assignment no sir, more distribution ta. But somehow I have been told that more assignment अछि मु किंतु सेटा देखि पाबो
कहिगिरी बा
सेटा रेसिडुअरी मैटर आसले आइटम 1 हो मोर रेसिडुअरी नाही नॉट असाइन्ड होछि Hon'Ble Justice Rautray.
PD procurement process 25-26 ପାଇଁ ତାଙ୍କୁ participate କରିଛନ୍ due to non-registration.
जे procurement for assignment नहीं सर regulated RMC Act और paddy procurement नहीं था जे मोर खाली PDS अछि distribution आपण चाहुचंती माने registration and किनिबा
ना बिकिबा
सॉरी बिकिबा
PD procurement process participate due to non-registration. They are not being allowed to sell their excess PD to the government.
The matter relates to procurement of paddy for the co-season seta kharif
25-26
For the Rabi crops 26.
Rabi
yes
Rabi season पे
कोड आपण कॉस्ट एटले केएमएस लिखाइ छी रबी केएमएस रो फुल फॉर्म कोन
खरीफ मार्केटिंग
खरीफ मेन सीजन मार्केटिंग की खरीफ मार्केटिंग सीजन आ रबी केमती होबो
अगर एडवर्टाइजमेंट अछि रबी क्रॉप्स पर केएमएस लिखाइ छै पेज 12 वर्ष
केएमएस 25
खरीफ मेन सीजन बदे केएमएस तो खरीफ मार्केटिंग ना खरीफ मेन सीजन इंक्लूड है नॉट रबी
লেখা আছে রবি ক্রপস ফর দি ইয়ার KMS 25-26 পেজ 12 subject note farmer registration for procurement of paddy in bracket
KMS 25-26 over now.
KMS 25-26.
The petitioner, the petition involves, you are challenging this.
No, challenging, not, it's a prayer to timeline given. Some farmers are left to be registered because of
The
the
writ
short
petition
time.
pertains to the procurement of paddy into bracket Rabi crop for the KMS
25-26.
2025-2026.
Yes.
The registry shall verify the determination and list the matter before the assigned bench.
Can it be tomorrow?
How can I direct the other bench? Please appreciate that. The petitioner shall have the liberty to mention the matter before for listing before the assigned bench. Yes, next.
24.
I'm applicable petitioner.
Mr. S. Malik. P.K. Malik.
There is delay of lots of 152 days.
What is the challenge? What is the revision about?
Order of government passed in CRB number 52 of 2021. 125.
Yes. You'll secure the amount? Have you paid anything? Then what can be done, sir? And for the last 4 years, the matter is kept pending. The petitioner before this court is the husband in the marriage. He challenges by filing the revision. The judgment dated 31/3/2022 passed by the Learned Judge Family Court Fulbari in C.R.P. number 52 of 2021. By the said judgment, the petition filed by the wife in the marriage has under section 125 of CRPC seeking monthly maintenance has been allowed. The learned counsel for the petitioner is apprised of the judgment rendered by the Honorable Apex Court in Rajneesh versus Neha, wherein it has been held that the amount directed to be paid as maintenance to the wife and child amounts to a money decree, is akin to a money decree. When such direction is issued under section 125 of CRPC. He is also apprised of the provisions contained in the Order 41, Rule 10, into bracket 1, 3, then 3 capital, 3 dash capital A, 10 and 11. Para. Actually, कल जो order दिला जैसे repeat कर देना है better. Rajesh for this one. On being asked, the learned counsel for the petitioner further submits that he has no instructions whether the petitioner has in any manner deposited any amount as directed by the Learned Judge Family Court towards maintenance stuff. The petitioner has adjournment to file affidavit indicating how he will secure the amount that remains in the area, that is rupees 5,000 into rupees 5,000 from law at Equisi Rupees 5,000 into 28. Yeah. The affidavit shall be filed by. Yes, Mr. Malik. The date be bhuli ठीक है मोटे डेट देख obviously 2 weeks not the जाउची चिंता है the affidavit shall be filed by 27/7/2026 the matter shall be listed for orders in the week commencing 3/8/2026 copy of this order shall be forwarded to the London Judge Family Court Fulbani to be kept in the records of so and so CRP number 52 of 2021 stop the by the registry. The registry shall also obtain a report from the learned judge family court if an execution case arising out of the said CRP is pending, and if so, the status of the said execution shall also be intimated. Stop. Yes, next.
25. None appears for the petitioner. None appears for the petitioner when the matter is called. The defects as pointed by the stamped report shall be removed within 10 working days. Copy of this order shall be communicated to the learned advocate on record for the petitioner by the registry. Shall be communicated by the registry to the advocate on record for the petitioner. Yes, next. 26.
26 रे से डिफेक्ट रिमूवल करना है तो 22 में से पिटिशन भी देना है तो सबूत लिखि देबे 25 रे द मैटर इज पेंडिंग सिंस 202 25 रे लिखन तू आपनकर एटा होची केते 26 245 अच्छा द मैटर वाज प्रेजेंटेड बिफोर 26 लिखियो द मैटर वाज प्रेजेंटेड ऑन दिस कोड 30 से 9 20 22 and defects were directed to be removed by the deputy registrar into bracket J judicial comma logima by order dated 21/11/2025. So by order dated 1/5/2026, a copy of the order was directed to be served to be communicated to the learned counsel for the petitioner by the registry. The communicate hela ki nahi likhile to apparently since 2022 no steps are taken to grant further opportunity to the petitioner. The matter shall be listed in the week commencing 27/7 week commencing what date कर देला what specific date कोटा कर देला 13/6/20 को week रे हपरे
20
on 20/7/2026 indicating that the matter shall be disposed of. Sir, SK Panigrahi. Opposite party likhibe Mr. SK Panigrahi on behalf of AP Bose for the opposite party. Copy of this order along with the order dated 1/5/2026 shall be intimated by the registry to the learned counsel for the petitioner. Yes, next.
28.
Yes, Mr. Sahoo, this is Josnabai Sahoo for the petitioner, opposite party. Mr. P.K. Nigam for the opposite party. Yes.
This has come for orders.
Yes.
Lordship, there's a stay in this matter.
Yes.
Has filed a petition for the opposite party has filed a petition for vacation of stay. Lordship, if the stay is vacated, the purpose will be frustrated. Your Lordship may finally hear the matter.
This is for what, sir?
For
Madam,
orders.
what is the prayer?
Yep, your lordship, at the final stage of, the only crux of the matter is that at final stage of hearing, the learned court below has allowed a petition for recall and to exhibit some documents which were a part of the sessions trial case. So that was in the year 2016, which was well within in the knowledge of the opposite party, but he did not, after 2 years, he has filed the civil proceeding in the year 2022. And in December 2023,
But you are saying that it should not be heard today. Because,
your lordship, I am ready. I am ready. Your lordship may post it for final hearing in any date. Otherwise, I am ready today. Your lordship may hear this matter.
under which proof? I mean, did you file your objection to before the learned trial court?
Yes, your lordship.
Have you taken that this stand?
Yes, your lordship. I have taken all the stand that at this final
So,
stage.
so the answer is that the learned judge trial court has considered and rejected your contention.
Yes, your lordship. He has applied section 14, wherein he can accept any document or
The matter is listed for orders as an application for vacation of the interim order has been filed by the opposite party. It is submitted by the learned counsel for the petitioner that unless the matter is heard finally, it will be rendered infructuous if the interim order is vacated. She requests for posting the matter for hearing. The matter shall be listed for admission in the week commencing 10/8/2026. Interim order dated so and so shall continue till the next date of hearing.
29.
Joshi?
Yes.
Mr. S.K. Joshi for the petitioner.
I filed IA that 81 of 2025 for exemption of payment of court fee.
Exemption on the ground?
Your lordship, see that page 2, para 3 I have given. Your lordship, the income certificate issued by the Tahsildar, local Tahsildar. My income is less than rupees 1 lakh. Page 6.
Yes, got it. I have to be fast also. No?
Yes, yes.
Like you.
No, absolutely.
So when you answer a proper question properly, so that is enough. Mr. S.K. Joshi for the petitioner. This person is a tenant under you.
A land house under the lower in the irrigation project.
So S.K. Joshi for the petitioner, Mr. Anshuman Sethi, additional standing counsel for the opposite party. As per the staff report, deficit, IA according to order, IA 81 of 2025. As per the staff report, the deficit court fee of rupees 9,422 has not been paid. The IA has been filed seeking exemption of the
payment of
court fee on the ground that the petitioner comes within the criteria
of exempted.
Within the criteria for getting exemption from paying the court fee in view of his income.
Yes.
Stop. Copy of the IA has been served, Mr.
Yes.
Yes, your lordship.
The copy of the IA has been served on the opposite party state. The learned ASC shall obtain instruction in response to the prayer made in the IA and file affidavit if so advised.
Your lordship.
File affidavit advised one. I will have to file the affidavit because he is filed certificate. The matter shall be listed for orders in the week commencing 3/8/2026. Yes.
30.
So SSK ନାଇଁ କଣ ଆସୁନାହାନ୍ତି କୁଆଡେ ଯାଉଛନ୍ତି?
Matter is similar though.
But ସେ ନାହାନ୍ତି ସେ ଅର୍ଡରଟା ହେଇପାରିଥାନ୍ତା.
Your lordship.
କପି ସର୍ଭ ହେଇଛି କି? ଦେଖନ୍ତୁ. ଅଛି?
Yes.
Petitioner none. Opposite party additional standing counsel, Mr. Anshuman Sethi. ଏଥିରେ ଆୟ ହବ 61 of 2025.
61.
ଆଉ ଟଙ୍କା ହଉଛି 2,225 ଟଙ୍କା 25 ପଇସା. 525. Same order. ସେଥିରେ hard loaded counsel for the petitioner ଅଛି ଉପରେ appellant petitioner. आज लाइट add କରିଦେବେ. had on counsel for the appellant petitioner. ଆଜ୍ଞା ତାପରେ ହେଲା ବଟ୍ ଏଥିରେ ଯେହେତୁ ନାହାନ୍ତି କିଛି ରହିବନି ୟେସ୍ ନେକ୍ସଟ ୟେସ୍ ମିସ୍ ଘୋଷ କୁଆଡ଼େ ଗଲେ କଲ୍ କରନ୍ତୁ ଆଜ୍ଞା ଆପଣ ବି କଲ୍ କରୁନାହାନ୍ତି
To 32,
ଟାକୁ ସିମ୍ପଲି ଆର୍ଜନ କରିଦେବେ ସମସ୍ତଙ୍କର ଆର୍ଜନ ହେଇଗଲା ନନ୍ ଆପେରେନ୍ସ ହେଲା ଏଟା ବି କରିଦେବେ ଅର୍ଡର ସେ ରଖିବେ ଆପଣ ଯୋଉଟା ଯୋଉଥିରେ ଅଛି ଡେଟ୍ ଟା ମାର୍କ କରିଦେଇଥାନ୍ତୁ ୟେସ୍
33,
after notice matters I am not here because I'm trying to complete whatever is there ଆପଣଙ୍କ ମ୍ୟାଟର ଖାଲି କୋନ୍ ଯେ ଅଛନ୍ତି 33 yes yes
For paying of 3,000 per month.
okay
सेटा भी से आजी पर्यंत दोनांती टंका देना
acha it is that matter you have been mentioning also ଆସିଲେ ସେ 3,000 ବି ଦଉନାହାନ୍ତି
Regularly दियो
ରେଗୁଲାର
ଆଜ୍ଞା
ତାହେଲେ ଗୋଟେ affidavit ଦିଅନ୍ତୁ
ଆଜ୍ଞା
ଠିକ ଅଛି
ତିନି
it is Mr. Jyotirmoy Sahu for the petitioner
ठीक नो एई न कुछ ସିଏ 3,000 ତାପରେ ଚାଇଲ୍ଡ କୁ ବି 3,000 ଆଜ୍ଞା ଏବେ ଦିଆ ହଉଛି
ଏଥିରେ ଆପଣଙ୍କ ପାୱାର ନାହିଁ
କଲା ପରେ ଆଜ୍ଞା
ଶ୍ରୀ ରାଉତରାୟ ଆପଣଙ୍କ ପାୱାର ନାହିଁ ଏଥିରେ ତ Mrs. S. Rautray on behalf of RK so please repeat your name Madhusnata M. Rautray so I was trying to recollect that so I could not Madhusnata Rautray for on behalf of Rasmikanta Patnaik for the opposite party regarding payment the compliance of the interim order dated what is the date of the interim order directing 3,000 9/12/2022 it is submitted by the learned counsel for the petitioner that the petitioner goes on regularly paying the amount of rupees 3,000 per month to the wife as well as 3,000 to the child. The petitioner shall file affidavit giving the details of the payments in brief such as date of payment, mode of payment, amount paid and the total amount paid. The affidavit shall be filed Mr. Sahu by Satish Sathe. 400 Satish Sathe ହେବନି ତାପରେ ଚାହୁଁଛନ୍ତି 3/8 by 3/8 upon serving copy thereof on the learned counsel for the opposite party the matter shall be listed for orders for admission in the week commencing 10/8 yes Mr. Bhuya
34,
interim order to continue
interim order dated so and so shall continue till the next date of hearing
okay
item 33
yes lots
so Bhuya the rest of the matters if nothing is urgent I have not start hearing and open the brief so that things are kept hanging Mr. Acharya you are in that 34
item 14,
40 34 date करो तो 34 give a date
who counts in 10/8,
so Bhuya 10/8 that's it that serially जानतु 35
35,
35 Mr. Mitra mention करते
किसी डेट दे
My lord,
अच्छा
35, my lord, but I am audible, my lord.
yes little bit cracked maybe impact of the evening yes
Yes, the weather is down, my lord. That is.
yes
My lord, I only pray, my lord, if lordship may keep it to tomorrow, if you must have some.
tomorrow ରଖନ୍ତୁନି
ଆଜ୍ଞା
there is no
ନାଇଁ କଣ ହେଇଛି 8 ତାରିଖ ଦିନ ଟ୍ରାଏଲ କୋର୍ଟରେ ରଖିଛନ୍ତି ମୋର ସେ ସାଲାଡ ଆଟାଚ କରିବା ପାଇଁ 2.5 ଲକ୍ଷ ଟଙ୍କା ମୋର ଦବାକୁ ଅଛି ଆଉ ଦ ମ୍ୟାଟରରେ ମତେ
ଦିଅନ୍ତୁ 2.5 ଲକ୍ଷ ଟଙ୍କା ଦେଲା ପରେ ବାକି ଯାହା ରହିଲା ସେଟା ଫ୍ରି ହବ
ନାଇଁ ମୁଁ କିଛି 2.5 ଲକ୍ଷ ଟଙ୍କା ଯୋଉ ଅଛି ମୁଁ 50,000
3 ଲକ୍ଷ ପରେ 50,000 ଆପଣଙ୍କ ଫି 2.5 ଲକ୍ଷ ଟଙ୍କା
ଆଜ୍ଞା ମାନେ ମୁଁ ଖାଲି କହିବି କି ଯାହା ବି କିଛି କାଇଣ୍ଡଲି ଡାଇରେକ୍ଟ ମି ଅଲ୍ ଡିପୋଜିଟ୍ ସମ୍ ଆମାଉଣ୍ଟ and let matter come
ପୁରାଟା ଡିପୋଜିଟ୍ କରନ୍ତୁ
ପୁରାଟା ଆଜ୍ଞା
ପୁରାଟା ଆଜ୍ଞା ମୁଁ ତ କାହାକୁ ଆଲାଉ କରୁନି ସେଥିରେ ବାର୍ଗେନ୍ କରିବା ପାଇଁ ତେଣୁ ଆପଣଙ୍କୁ କହିବାଟା ଅସୁବିଧା ହବ ବୁଝିପାରୁଛନ୍ତି
ଏଲିଂ ମଦର
but
ମୁଁ
others will think
ailing mother କହିଲା
today at least I have passed almost 10 orders. You
ନାଇଁ
think
ମୁଁ
about
ଜାଣିଛି ଆଜ୍ଞା ମୁଁ
yes.
ମୋ କଣ ମାଇ ମଦର ଇଜ ମାନେ ମୋ ଟ୍ରିଟମେଣ୍ଟ ସେଥିପାଇଁ ମୋର ଟିକେ ଦିଟା ଇନଷ୍ଟଲମେଣ୍ଟ କି ତିନିଟା କରିଦିଅନ୍ତୁ ମୁଁ ସେଇ 2.5 ଲକ୍ଷ ଟଙ୍କା
ଆରେ
ଡିପୋଜିଟ୍
ଆପଣ
କରିଦେବି
ତ ଦେଲେ ସିନା ହବ ଆପଣ ତ ଦଉନାହାନ୍ତି ଦେଲା ପୂର୍ବରୁ ଆପଣ ଯଦି ଦେଇ ଦେଇଥାନ୍ତେ ତ ବର୍ତ୍ତମାନ ମିଷ୍ଟର ଦାସ କହିଥାନ୍ତେ ମୁଁ କହିଥାନ୍ତି ତାଙ୍କୁ ଆଜ୍ଞା ସେ ଦଉଛନ୍ତି ଠିକ ଅଛି ଦେଖନ୍ତୁ
ଆଜ୍ଞା କଣ ହେଇଛି ନା ଗୋଟେ
did you
ଗୋଟେ
mark
ମାଟାରେ କନସଲେସନ ବି ଅଛି
Mrs. Rautare said that ସେ ଦଉନାହାନ୍ତି but they were confident ସେ କହିଲେ ଯେ ଆଜ୍ଞା ଆମେ 6,000 ଟଙ୍କା ଦଉଛୁ
ନାଇଁ ନାଇଁ ମୁଁ
So
ଦଉଥିଲି
ଆପଣ
ଆଜ୍ଞା ସବୁ
ଆପଣ ଯଦି
ଦେଇଛି
ଆପଣ ଡିପୋଜିଟ୍ କରନ୍ତୁ କାଲି ଆସିଲେ ଆପଣ 1 ଲକ୍ଷ ଟଙ୍କା ଡିପୋଜିଟ୍ କରିବେ
ହଉ ଲକ୍ଷ ଟଙ୍କା କରନ୍ତୁ ଆଜ୍ଞା ହଉ
ଠିକ ଅଛି
କାଇଣ୍ଡଲି
ଠିକ ଅଛି ମୁଁ ନାଇଁ ମୁଁ even I know that they will not listen to you 18 ତାରିଖ ମାନେ କୋଉ 18 କହୁଛନ୍ତି ଜୁଲାଇ
8 ରେ ଅଛି ଏଇ 8 ରେ
ଆଜି କେତେ ତାରିଖ ହେଲାଣି
I do.
2 ଠିକ ଅଛି 6 ରେ ଆସିବ 6 କି 7 ରେ ଆସିବ କୁହନ୍ତୁ
ଆଜ୍ଞା 7 ରେ
6 ରେ ଆସୁ ଆପଣ କାଲି ଡିପୋଜିଟ୍ କରନ୍ତୁ କି 7 ରେ ଆସୁ ଠିକ ଅଛି 7 ରେ ଆସୁ
ହବ କାଲି ଫ୍ରାଇଡେ
ଆପଣ
ଅଛି
ଯୋଉଟା
ମୁଁ
ଡିପୋଜିଟ୍ କରିବେ
ମଣ୍ଡେ ହଁ
ମଣ୍ଡେ ସାର୍ 6 ମଣ୍ଡେ 6 ମଙ୍ଗଳବାର 7 ଆପଣ
ବାଇ
8
ମଣ୍ଡେ ମୁଁ ଡିପୋଜିଟ୍ କରୁଛି 1 ଲାख रुपए କାରଣ 8 ତାରିଖ
ସେଟା ଯାହା ଡିପୋଜିଟ୍ କରିବେ ମିଷ୍ଟର ଦାସଙ୍କୁ ଦେବେ କପିଟା
ହଉ କପିଟା ଦେବି
ପାର୍ଟି
1 ଲାख रुपए
ଝିଅଟା ଡେଷ୍ଟିଚ୍ୟୁଟ୍ ଝିଅ ତାର ଛୁଆଟି ବି ଅଛି ଡାଇରେକ୍ଟ ତାକୁ ଦେଇଦେଲେ ଚଳିବ
my lord I suggest since the date is fixed
ଝଗଡ଼ା ଲାଗୁଛନ୍ତି ସେ ସେଥିପାଇଁ ବେଟର ଅଛି କୋର୍ଟରେ
ନାଇଁ କଣ କି ଆଜ୍ଞା honorable justice ପାଠକ and justice which are directed for conciliation ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ ହେଇଥିଲା ସେଇଟାକ ଇଏ ବି ରାଜି ଅଛି ମା ଝିଅକୁ ନେଇଯିବା ପାଇଁ
ମତେ ପାଠକ
ଏନିୱେ
ସାହେବ ମନା କରିଛନ୍ତି ମତେ ପାଠକ ସାହେବ ମନା କରିଛନ୍ତି କୋଉଥିରେ ଏମିତି ଟଙ୍କା ପଇସା ତମେ ପଶିବନି ସେଟା ମତେ କୁହନ୍ତୁ
ଏଇ ଟଙ୍କା ଦବ ସେଇଟା
I have to obey
bound to
my
give
senior also
bound to give
ଆରେ ଦିଅନ୍ତୁ ଆଜ୍ଞା ଅସୁବିଧାରେ ଅଛନ୍ତି ଲୋକ ବୁଝନ୍ତୁ ତାଙ୍କ କଥା
ଆଜ୍ଞା 1 ଲକ୍ଷ ଟଙ୍କା ଦଉଛି କାଇଣ୍ଡଲି ଡାଇରେକ୍ଟ 8 ତାରିଖ ଦିନ ସେ 8 ତାରିଖ ତ ସେଇଠି ଦେଇଦବ ସେ ଟ୍ରାଏଲ କୋର୍ଟ ଦେଇଦବ
showing you the indulgence that I am not recording but please come back after paying and show the evidence to Mr. Das. He is also very
As you
nice,
lordship,
so you
please.
will accept that. No problem.
As you lordship please I'll
No, both of you please, because I am not pleased. I'll be very happy if you give 2.5. That I'll be really pleased.
it is difficult 1 lakh that as you lordship 1 lakh
ତେଣୁ ମତେ କାଇଁ ପ୍ଲିଜ ହେବା ପାଇଁ କହୁଛି ମୁଁ ତ ମନା କଲି ଆପଣ ତ ପ୍ଲିଜ କରିପାରିବେନି ମତେ
ଆଜ୍ଞା
7 ତାରିଖରେ ରଖିବେ ହେଲା
ଆଜ୍ଞା
but I have difficulty in forgetting Mr. Mishra. Please remember that.
ये lordship record my
I am
submission
not able to forget.
आगे record कर दियंतु काइंडली record
नहीं ठीक है yes 7 को रखिए yes
obliged blood
Mr. Mishra, you are saying which matter? ठीक है anyway फिर हे गला you had mentioned which matter I was just trying to
35 this matter 30
ठीक है
आगे grateful my lord obliged grateful
37 डेट कर दियंतु 38
वही कौन से
38 मेंशन ହେଇଥିଲା କରିଛନ୍ତି
38 ଟା ଯାଇଛି
ଆଚ୍ଛା
ଅର୍ଡର
ଅର୍ଡର ଡାକିବା ଦରକାର
ହେଇଯାଇଛି
ହେଇଯାଇଛି ଠିକ ଅଛି ଆଚ୍ଛା ଆଜି ପରେ ସକାଳେ ଅର୍ଡର ଡକା ହେଇଯାଇଥିଲା 39 ଡେଟ୍ କରି ଦିଅନ୍ତୁ
वही कौन से 10 8
ହଁ ଠିକ ଅଛି ଆପଣ ସେ ପଚାରିଲେ କହିବେ ମିଷ୍ଟର ଆଚାର୍ଯ୍ୟ 41
Notice was issued, the opposite party has appeared, my lord.
Mr. Boral's associate was present. If it is
Not informed me. If he had,
नहीं से adjournment नहीं ना दिस आउट मैटर अपील करते हैं 41 डेट करो तो when do you want you suggest
any date.
ठीक है करो तो
वही कौन से 10 8
Deeply.
लेफ्ट पासवर्ड किस है
नहीं सर
थैंक यू